Section 12. Unit 2, Types of Foreclosure. Lesson 1, Foreclosure. Lesson 2, Common Foreclosure Types and Procedures. Lesson 3, Other Foreclosure Processes. Additional Foreclosure Processes. Foreclosure by advertisement. The borrower who has defaulted on the mortgage is notified by the lender of the impending foreclosure, and that the property will be sold at public auction. The winner of the auction becomes the new owner of the property, but doesn't get possession until the previous owner has vacated the property. This often requires legal action to dispose of the default and bring an order of eviction. Foreclosure by entry and possession. In several states, e.g., Maine, Massachusetts, New Hampshire, and Rhode Island, the lender may ask the court for permission to physically take possession of the property after default has occurred and foreclosure is imminent. If court permission is obtained, the mortgagee can take the property peacefully and in the presence of a witness. If the mortgager is unable to redeem the property, the mortgagee may sell it by trustee sale. Foreclosure by writ of entry. This additional action is used in Maine, Massachusetts, and New Hampshire. In the case of foreclosure by writ of entry, the mortgagee asks the court for a writ of entry action. This means the borrower is given a final deadline when delinquent payments are due, and after that time, the mortgagee becomes the full legal owner of the property. Judicial versus non-judicial foreclosure and sale. In most states, if the borrower has defaulted, the lender sends the borrower a notice informing her that she's late and about to get foreclosed on if she doesn't figure it out, Mike said. Yow. That's something I hope I never see in my mailbox, Kira said with a shudder. Well, it's not like the homeowner didn't know she was late. The terms regarding notice of sale are specified in the mortgage documents. You mentioned earlier that foreclosure is a judicial process. Is there any other kind? In some states, the foreclosure can be non-judicial. Can you explain the difference between the two? Kira asked. Sure. Non-judicial means it doesn't involve a lawsuit. In some states, a non-judicial foreclosure is allowed if the security instrument or note includes a power of sale clause. Because the right to sell is granted with that clause, no court action is required for the lender to sell the property if the borrower defaults. I feel smarter already, Kara said. Thanks. Happy to help, Mike said. Judicial and non-judicial foreclosure and sale. Judicial foreclosure and sale. Judicial foreclosure and sale is a process that requires the lender to seek the court's permission to foreclose on property that has fallen into default. The property was used as collateral for the mortgage loan, and the lender seeks the court's permission to foreclose in order to recoup its investment. Non-judicial foreclosure and sale. Non-judicial foreclosure and sale may be used when the deed of trust includes a power of sale clause. The power of sale clause allows the lender to sell the property used as collateral without seeking the court's permission. Conveyance through foreclosure. When a property is encumbered by a lien, and that lien isn't paid, e.g., the borrower doesn't make mortgage payments, the lien holder may foreclose on it and force a sale. If taxes aren't paid, the property may be sold at public auction to satisfy the lien. Even contractors, by virtue of a mechanic's lien, retain the right to foreclose on the property in order to get paid. Obviously, the mere act of foreclosure doesn't get anyone paid. The property must be sold at auction to reap the funds to pay lien holders. When the foreclosure process is complete, the court appoints a referee, e.g., a sheriff, trustee, or commissioner, to auction off the property. The owner's consent isn't required. The lien itself gives the lien holder the right to foreclose in order to generate the funds. The sale is ordered by the court, or authorized by state law, and title is conveyed to the buyer through the use of a judicial deed, also called a referee's deed, which will be either a sheriff's, trustee's, or commissioner's deed, depending on who is authorized to conduct the sale. The referee's deed conveys the real property to the new buyer. If the proceeds from the sale aren't enough to pay off the lien holder will often place a deficiency judgment against the property owner for the outstanding balance. Foreclosure defenses. Thankfully, because foreclosure results in involuntary alienation of real property, legal remedies for the property owner are available. The simplest remedy is payment of outstanding debt. If the property owner can satisfy liens against the property before the foreclosure has occurred, it can be prevented. This is known as the right of redemption. If the foreclosure is being pursued by a mortgage holder, for instance, the property owner can repay the principal amount of the debt owed, accrued interest, and the lender's costs of foreclosure to the lender, and redeem the property. This right ceases when the foreclosure sale is held. Bankruptcy can also forestall foreclosure. If a property owner files for bankruptcy under Chapter 7 of the United States Code, the title to the property is transferred by operation of bankruptcy law to the trustee of the bankruptcy. This means that it cannot be reconveyed to a lien holder or anyone else without the approval of the trustee, as well as the execution of the appropriate documents. Both corporate property owners and individuals can file for bankruptcy under Chapter 11, which prevents creditors from proceeding with a foreclosure action. But in order to qualify for Chapter 11, the individual or corporation has to propose a plan to the bankruptcy court that demonstrates how they intend to reorganize their finances. With Chapter 11, debtors typically retain title to the property, but they hold the property in trust and then have the duties and powers of a trustee of the bankruptcy. Chapter 11 is a more complicated process than Chapter 7. Unit 3, Deficiency Judgments and Foreclosure Reduction. Lesson 1, Understanding Deficiency Judgments. Lesson 2, California Foreclosure Reduction. Lesson 3, Understanding the Tax Implications of Foreclosure. Lesson 4, Defaults and Foreclosures Study Sheet. Defaults and Foreclosures. Study Sheet. Borrower default. Non-payment of property taxes. Missed mortgage payments. Non-payment of homeowner's insurance, lender's investment, loan, is at risk if property used as collateral is destroyed. Non-payment of homeowner's insurance can lead to default. Poor property maintenance. The lender's security is the resellable asset in case the borrower defaults. Poorly managed property that requires repairs before it can be sold causes the value of that asset to decrease, putting the lender's investment at risk, and the borrower in default of the agreement to maintain the property. Foreclosure occurs when the borrower, usually the property owner, defaults. Form of involuntary conveyance. Common foreclosure types and procedures. Non-judicial foreclosures, no lawsuit, power of sale clause protects the lender's right to foreclose. Judicial foreclosures, lender files suit in court, receives judgment allowing sale, public is notified, and property is sold at public auction to the highest bidder. California Foreclosure Reduction. California Foreclosure Reduction Act, aka the Homeowner Bill of Rights, regulates lenders with high rates of foreclosure, provides for options for borrowers to avoid foreclosure. Deficiency judgments. Lender's pursuit of amounts still owing after foreclosure sale. Rarely used. A recourse mortgage gives the lender a way to sue the borrower for damages after foreclosure. A non-recourse mortgage prohibits the lender from suing the borrower for damages after foreclosure. FHA does not allow alternatives to foreclosure. Loan modification, short sales, moratoriums, recasting, and voluntary conveyance of deed. Loan modification. Used when a borrower is having trouble making mortgage payments to help make the payments more affordable and avoid foreclosure. Car short sale addendum. Notifies parties that the sale is dependent on lender approval. Tax implications of foreclosure. If the lender waives a deficiency, amount still owed by borrower, this may be counted as taxable income for the borrower. Recourse loans versus non-recourse loans. Recourse loans. A mortgage loan with a recourse clause gives the lender a way to sue the borrower for damages after foreclosure. If selling the property after foreclosure didn't result in enough profit to cover the outstanding debt on the original loan, the lender has a legal means, recourse, to collect the outstanding debt. Non-recourse loans. A mortgage loan with a non-recourse clause prohibits the lender from suing the borrower for damages after foreclosure. In this case, if the foreclosure sale didn't result in enough profit to cover the outstanding debt on the original loan, the lender is out of luck. Considerations. Borrowers should understand their loan documents thoroughly so they're not caught off guard by extra expenses in the event of a foreclosure. This includes knowing whether their mortgage loan is a recourse or non-recourse loan. State legislation may dictate whether recourse or non-recourse loans are legal, but laws can change, so it's important for borrowers to know the laws in their state. Having a non-recourse loan doesn't necessarily mean the borrower will walk away owing nothing. The IRS views foreclosures as sales, which means there are potential tax liabilities after a foreclosure. Borrowers should check with their tax advisor to determine whether they'll owe any additional taxes due to their foreclosure. Additional information about the potential tax implications of foreclosure can be found on the IRS website at California Foreclosure Reduction Act. The California Foreclosure Reduction Act, commonly referred to as the Homeowner Bill of Rights, was enacted January 1, 2013. The purpose of the act is to reduce the number of foreclosures that occur by establishing regulations for mortgage lenders. The act applies to lenders that have a high number of foreclosures annually, currently 175. Regulations include prohibition of dual tracking. Mortgage lenders can't pursue foreclosure when the borrower has applied for a loan modification that is in process. If the borrower doesn't accept or fails to comply with the loan modification terms, then foreclosure can proceed. Single point of contact. When a borrower requests assistance to avoid foreclosure, the lender has to designate a single point of contact for the borrower to provide information and help the borrower with any alternative processes. Loan modification review process. The lender must have an established review process for loan modification applications and communicate that process to its borrowers. Loan modification application denial and appeal. The lender must notify the borrower when an application for loan modification has been denied. The lender must also provide the borrower with instructions on how to appeal a denial. It must also give the borrower 30 days to do so before taking further action, e.g., notice of default, foreclosure. Review of foreclosure documents. Before the foreclosure process can begin, the lender must review its documents for accuracy and completeness. Foreclosure can't proceed without evidence that the borrower's default has been thoroughly substantiated. Additional information on the California Foreclosure Reduction Act can be found on the California Department of Business Oversight website. Deficiency judgments and blanket liens. When a lender sues a borrower for a deficiency judgment, it's an attempt to recoup the losses the lender sustained in the default and foreclosure process. The deficiency judgment may include a blanket lien, which will allow the lender to place a lien against any current or future property the borrower owns, until the losses are recovered. The blanket lien also extends to any cosigner on the loan.